I am here to represent the Delegation of Ireland and give you an introduction to formation of contracts in Irish law. Ireland is a common law system, and as such there is no civil code, and contract law is created and developed through statutes and case law. Formation of contract consists of three main elements: an offer, an acceptance, and intention by the parties to create legal effect. Due to the nature of the common law system, to provide a comprehensive introduction to the formation of contracts, I would need numerous cases and a lot more time than we have. So to exemplify the Irish position in the European law, contract law, we must use an example, and I'm going to focus on the element of intention to create legal effect. There's a general acknowledged presumption that no agreement will be enforced unless that was what the parties intended. But the Irish law distinguishes further presumptions, and one being that commercial agreements are meant to be enforceable, and as such, commercial agreements automatically have an intention to create legal effect, and this rule is extremely hard to rebut, as established in Edwards and Skyways. But contrasting this, there's a strong presumption against the enforceability of family agreements, as exemplified in Hano versus Sidway. Therefore, the intention to create legal effect is seen as as being absent in agreements between family members. And to establish whether this intention exists, an objective test based on the facts of the case with reference to a reasonable third party and how they would interpret enforceability is used to see if this intention was present in and there was a formation of a contract. This distinction and presumption shows clearly that requirements for formation of contracts in terms of when intention exists is based on developed case law and in accordance with social context. This alone indicates the difficulty in codifying such law when an objective test is based on individual facts of cases and to assess whether formation has taken place. This is just one example of clearly important nuances in the law of contract in Ireland, mostly based on the common law tradition that cannot adequately be replicated in a European civil code. My colleague will now give you a comparison with this Irish law with two other jurisdictions.
Hey, in this part of the video, we will talk about formation of contracts. We will look at Irish, English, and French law. First of all, starting with formation of contracts under Irish law. Under Irish law, there are three requirements that are valid for formation of a contract. This is offer and acceptance, consideration, and intention to create legal obligations. Starting with offer and acceptance. Offer exists where the offerer undertakes to be contractually bound if the offeree makes a proper acceptance. It is definite promise to be bound on certain specific terms. The essentials of a valid offer are as follows. The terms of an offer must be clear, certain, and complete. The offer must be communicated to the other party. The offer must be made by written or spoken words, or be inferred by the conduct of the parties. Finally, the offer must be intended as such before a contract can be concluded. Acceptance. There are a few essentials of valid acceptance. These are: acceptance may be oral, written, or implied from contact. Acceptance must be clear and unqualified and must exactly match the offer. Acceptance must be communicated to and received by the offerer. The other requirement for a valid formation of a contract under Irish law is consideration. Consideration is something of a tangible value that is given or forborne in exchange for a promise. One of the characteristics of consideration is that consideration need not be adequate, but must be sufficient. Adequacy has been established in Thomas Chappell and Company Limited versus Nestle case. Sufficiency says that a consideration must be something of value in the eyes of law. The other characteristic of consideration is that consideration must not be passed and must move from primacy. The third requirement is intention to create legal relations, and this is the final core requirement. The question that is being asked by judges and by the court is, would ordinary, reasonable men have believed that there was an intention to create legal relations? There are two main categories and presumptions: family, domestic, or social cases, where it is not that easy to establish intention to be legally bound, and commercial cases, when intention is very easy to establish. When it's about family, domestic, or social cases, presumption, when where existing, can be rebutted as the same as inevitably a question of fact to be determined on a case-by-case basis. When it's about commercial agreements, presumption that intention is present, unless rebutted by clear evidence that no such intention was intended. The nature of facts in each instance are key to establish whether the intention was there. Finally, form. There is no specific form as to create a valid and legally binding contract. Exception is Section 2 of Statute of Frauds Act 1965, which applies to various contracts requiring a formal note in writing and signed, main one being contracts for the sale of lands. This was the Irish part. Now we will move on to English law. Under English law, contract is an agreement giving rise to obligations which are enforced or recognized by law. There are three basic essentials to the creation of a contract. This is agreement, contractual intention, and consideration. When it's about agreement, agreement consists of an offer and acceptance. What is an offer? It is an expression of willingness to contract on specified terms, made with the intention that it is to be binding once accepted by the person to whom it is addressed. There must be an objective manifestation of intent by the offerer to be bound by the offer if accepted by the other party. An offer must be distinguished from an invitation to treat, by which a person does not make an offer but invites another party to do so. When it's about acceptance, acceptance is a final and unqualified expression of assent to the terms of an offer. There must be an objective manifestation by the recipient of the offer of an intention to be bound by its terms. An offer must be accepted in accordance with its precise terms, if it is to form an agreement. Acceptance has no legal effect until it is communicated to the offerer. The general rule is that a postal acceptance takes effect when the letter of acceptance is posted. This is the so-called postal rule. An offer may be revoked at any time before its acceptance. However, the revocation must be communicated to the offeree. Once an offer has been accepted, the parties have an agreement. Therefore, the first requirement of creating a legally and lawfully binding contract is met. The second requirement is consideration. Consideration must be sufficient but need not be adequate. Therefore, courts do not in general ask whether adequate value has been given. This is because they do not normally interfere with the bargain made between the parties. Consideration must not be from the past, meaning that the consideration from a promise must be given in return for the promise. Finally, consideration must move from the promisee in a way as the promisee must provide the consideration. The final requirement is contractual intention. An agreement, if it is supported by consideration, is not binding as a contract if it was made without an intention to create legal obligations. That is, the parties must intend their agreement to be legally binding. The same situation is present as under Irish law, that in the case of ordinary commercial transactions, there is a presumption that the parties intended to create legal relations, and it is quite harder to establish that in cases of family and social nature. Finally, form. The general rule is that contracts can be made informally, and most contracts can be made either orally or in writing, but there are some exceptions under which contracts to be valid, they have to be in writing. And this is, for example, lease for more than 3 years, must be made by deed. Also contracts for the sale or disposition of an interest in land, and contracts of guarantee are required to be evidenced in writing as well. Now we will move on to the French part. What is a contract? Article 1101 French Civil Code says that a contract is an agreement by which one or several persons bind themselves towards one or several others to transfer, to do, or not to do something. And under French law, there is a distinction between reciprocal and unilateral contracts. Formation of a contract, there are 4 conditions: the consent of the party which binds, her capacity to contract, a sure object which forms the matter of the commitment, and a lawful cause in the obligation. First, the consent. The consent is formed by the meeting of an offer and an acceptance. Offer must take on 2 characteristics. It must be a firm and precise proposal to contract. When it's about acceptance, it's defined as the expression by the offeree of the will to conclude the contract in the conditions proposed. Acceptance does not need to be necessarily expressed, so it can be derived from the performance of the parties, or one of the parties. Acceptance must be told to the offerer so that he is informed and the contract is formed. If the consent is expressed by the offer and acceptance, still it is necessary that the consent given by the parties is valid. Therefore, Article 1109 of the Civil Code enumerates the 3 defects of the consent which invalidates it. So this is when the consent was given by the error, or where it was extorted by the state, or abused by violence. The second requirement is capacity to conclude a contract. Article 1123 mentions this requirement, and this requirement is defined as the possibility for a person to have rights and obligations and to enforce them. The third requirement is object of a contract. Article 1108 says that the thing which is the object of the contract must exist. And thus, a sale contract cannot be formed if at the time of its signature the thing is destroyed or absent. However, the future thing cannot be the object of a contract. Moreover, the object shall be determined or determinable as required by Article 1129. The object shall be also licit, meaning that it cannot be contrary to the public order, the moralities, or prohibited by the law. The final requirement is the cause of a contract. The idea of a cause attempts to find the interest in which parties have in making the contract and to ensure that this interest is both serious and legal. The cause therefore shall exist as required by Article 1131 and be licit. The concept of cause is particularly relevant with regard to the legality of a contract. In cases where the object of the contract is illegal in criminal law, the law of contract intervenes and holds the contract to be void through lack of a necessary cause. It is interesting to note that the other jurisdictions would highlight the issue of public policy to prevent the contract from being enforceable, while French law in this field bases its reasons on the foundations of the obligations, and it has been derived from Hocus Pocus case. And the form: in general, contracts can be concluded orally or in writing. There is no specific rule as to the form. However, there are some exceptions under which contracts must be concluded. To be concluded must be in writing, and this is, for example, cases as regard proof of the obligations. That's all. Thank you very much for watching our video.